presentation, his intensity, and his ability to bring this issue before the American people and before the floor of the United States Senate. And I yield back my time.
Mr. President, how much how much time is remaining?
The senator from Ohio has 20 minutes. The senator from Wyoming has 12 minutes.
That brings us up to 12:30. First, Mr. President, I have 6 unanimous consent requests for committees to meet during today's session of the Senate. They have the approval of the majority and minority leaders. I ask unanimous consent that these requests be agreed to and the requests be printed in the record.
Without objection.
Mr. President, just a couple of things I just wanted to bring up here in response to some of the statements that were made here on the floor. First of all, I want to make it very clear that the NLRB has scrupulously followed all legal and procedural requirements for rulemaking under the Administrative Procedures Act. And by increasing the use of rulemaking, it has been the most inclusive and transparent board in history. This process has given all sides abundant opportunity to provide input to the NLRB. There's opportunity for written comments, written responses to other comments, and even a public hearing. Now, again, I want to point out there is no requirement in the Administrative Procedures Act to facilitate a dissent. Even though there isn't, the NLRB's traditional practices give Member Hayes the opportunity to dissent, and he was given that chance. But these practices do not allow him to filibuster or run out the clock to thwart the actions of his colleagues. Again, the board filed a notice of proposed rulemaking on June 22, 2011, provided 60 days for filing public comments, received over 65,000 comments, of which I might note all but 200 were form letters. 65,000 comments, all but 200 were form letters, but still 200 sharing a wide range of views, stakeholder input. The board arranged an opportunity for staff from Member Hayes' office to brief congressional staff on his dissent from the notice of proposed rulemaking. And again, although not required to do so, the board also provided an opportunity for oral public comments at a hearing conducted on July the 18th and 19th, 2011, in which over 60 labor and management lawyers, public interest groups, employer and labor organizations, workers, and other related constituents participated. The board provided an additional 14 days following the 60-day comment period in which to file written reply comments. Again, this is not required by the APA, the Administrative Procedures Act, or any other law. And then the NLRB held a public vote on a final rule on November the 30th, published the final rule in late December. So, quite frankly, under the Administrative Procedures Act, that all other agencies follow, the NLRB bent over backwards to be transparent and to allow dissent. Now, I've heard it said that Member Hayes was not allowed enough time. Well, he had his first dissent, but from June the 22nd until November, Mr. Hayes had all that time to file a dissent if he wanted to write a dissent. I mean, that's not enough time to write a dissent. It seems to me that's more than enough time. But that was not done, so I just want to make it clear. I think that Mr. Hayes was given more than enough time to write his dissent if he wanted to. He wrote, I just want to say, he did write one dissent over the proposed rules. He had the opportunity from June the 22nd until November. Again, the APA, the Administrative Procedures Act, and the rulemaking doesn't entitle him to a dissent. But the board allowed him to have a dissent if he wanted to. They had access to public comments on the proposed rules. They were given summaries and copies of specific comments the other members found informative. His office had months to incorporate those comments and write a second dissent, but chose not to. That was his own choice. That was his own choice. He was not prevented from doing so. That was his own choice. Now, again, well, there's a lot of little items like that that I think that are kind of being misinterpreted. But here's the essence of it right here. Here's the essence of what this is all about. Stripped of all the falderall and all of this and all of that, and what board member was for card check and who wasn't, and on and on and on. This is what it's about right here, this statement. This is Martin J. Levitt, who was an anti-union consultant for management. He wrote a book called Confessions of a Union Buster, published in 1993. Confessions of a Union Buster. Here's what he said. Challenge everything. Then take every challenge to a full hearing. Then prolong each hearing. Appeal every unfavorable decision. If you make the union fight drag on long enough, workers lose faith, lose interest, lose hope. That's what it's about. That's what it's about. It is about denying people their right under the National Labor Relations Act to fairly and expeditiously have a vote on whether or not to form a union. Now, this is not new. This has been going on. This has been going on since the 40s and 50s, since Taft-Hartley. There have been forces at work in this country since the adoption of the National Labor Relations Act in 1935, forces at work that want to break unions. They don't want to give workers the right to have a voice in collective bargaining. They'll go to extreme limits to deny union members their rights. They'll do everything they can to try to break up unions. Taft-Hartley was the first of that, and we've had several things since that time. But again, I think our job here is to try to make it a level playing field, as level as possible anyway, and to give workers a right that is not just a right in name only or in words, but a real factual, real right to form a union and have the election without challenging everything, taking every challenge to a full hearing, prolong each hearing, appeal every unfavorable decision. If you make the union fight drag on long enough, workers lose faith, lose interest, lose hope. And I might add, you drag it on long enough and it gives the employer every opportunity to intimidate workers so that they won't join a union, to maybe fire people who were active in the union organization drive but find some reason why they should be fired anyway. That's what this is about. What the NLRB has finally done is said, and through an open process, through a rulemaking process, through perhaps one of the most open, transparent processes in history of the National Labor Relations Board, what they've said is, let's have a system whereby certification votes can be held within a reasonable amount of time. There was no time limit put in there. There's no 7 or 10 days. That's what Mr. Hayes said in his dissent. He just plucked that out of thin air. Well, actually, he got, I think, from the card check from the Employee Free Choice Act. But that's what he did. But that's not in the bill. That's not in the ruling, I should say. That's not in the ruling at all. And most people that have looked at it have said, well, it may shorten it to 20 to 30 days, somewhere in there. It seems to me that's fair enough. That's fair enough. But that's really what this is all about, and I hope senators, when they vote, will recognize that what the board has done is it's taken that unfair process that we've had for so long and made it more fair for everyone. I will point out one last time that the procedures that the NLRB has come up with, what's under fire right now from the other side, applies to certification votes, also applies to decertification votes. If a company wants to decertify a union, then the union can't drag that out months at a time to drag that out for decertification. So it seems to me on both sides, certification, decertification, you have a level playing field, and neither side can drag it out interminably to try to frustrate the real desires and wishes of the workers. Mr. President, I yield the floor.
Senator from Wyoming.
I yield 8 minutes to the senator from South Dakota.
Senator from South Dakota.
Thank you, Mr. President. I want to commend the senator from Wyoming for his great work on this subject. As Americans know firsthand, Mr. President, we continue to struggle with an economy that's not performing well or meeting the needs of workers. The unemployment rate remains about 8%, has been the case for the last 38 months. Much of this can be attributed to a lack of certainty on the part of employers. One need look no further than the regulatory policies being pushed by this administration to understand why job creators are not creating jobs. Back on December 22nd in 2011, the technically independent National Labor Relations Board published the final rule on representation case procedures, better known as the ambush elections rule. This new rule could allow a union to organize an election in as little as 10 days. This new rule is the most drastic and sweeping modification to the union election process in more than 60 years. According to the National Labor Relations Board, the median time in which an election is held is 38 days. And 92% of all elections occur within 56 days. In fiscal year 2011, the National Labor Relations Board reports that 71.4% of unions won their elections, which is up 3.5% from fiscal year 2010. It is hard for one to claim, Mr. President, that union elections are being held up unnecessarily with these sorts of track records. The changes put forth by the NLRB will radically change the process of union organizations and will limit employers' ability to respond to union claims before an election, thereby stifling debate and ambushing an employer and employees. Employers use the time after an election petition has been received to ensure compliance with the National Labor Relations Act, to consult with human resource professionals, and to inform their employees about the benefits and shortcomings of unionizing. It's nearly impossible for a small business owner to navigate the regulations of the National Labor Relations Act without the assistance of outside counsel, which will be hard to find in 10 days or less. On April 21st in 1959, then-Senator John F. Kennedy stated, and I quote, "The 30-day waiting period is an additional safeguard against rushing employees into an election where they are unfamiliar with the issues," end quote. It appears that rushing elections is exactly what the NLRB and big labor are hoping for. After all, unions win 87% of elections held 11 to 15 days after an elections request is made. The rate falls to 58% when the vote takes place after 36 to 40 days. Now, on a decision as important as whether or not to form a union, workers should have the opportunity, Mr. President, to hear from both sides, free from any pressure one way or the other, an opportunity that the NLRB's recent decision would take away. In addition to ambushing employers with union elections, the NLRB has now decided to recognize micro-unions. The NLRB ruled that so long as a union's petition for unit consists of an identifiable group of employees, the NLRB will presume it is appropriate. Now, what does this mean for America's small businesses? Well, this means that at your local grocery store, there could be a cashier's union, a produce union, a baker's union, and the list goes on and on. Micro-unions coupled with ambush elections can cause one small business to deal with several bargaining units in the workplace and little time to no time to raise concerns against such actions. The Supreme Court, Mr. President, has expressly stated, and I quote, "An employer's free speech rights to communicate his views to employees is firmly established and cannot be infringed by a union or the NLRB," end quote. The recent actions of the NLRB have all but silenced any freedom of speech once enjoyed by employers. For the state of South Dakota, increased unionization will mean higher costs for the health care industry, driving up health costs for hospitals and consumers. It would also mean higher costs for hotels, tourism, small businesses, and other service industries. The federal government should not be acting to slow or hinder job growth in our current economy, but should instead be looking for ways to foster job growth. In addition to radically changing the way in which union elections are organized, the NLRB promulgated a rule requiring most private sector employers to post a notice informing employees of their rights under the National Labor Relations Act. I believe that this is yet another example of federal overreach by this administration that benefits their special interest allies at the expense of American businesses that are currently struggling to create jobs, which is why I introduced the Employer Free Speech Act last year. If enacted, this legislation would prohibit the NLRB from requiring employers to post a notice about how to establish a union. I'm happy to report that on April 17th in 2012, the D.C. Circuit Court of Appeals agreed with me and has stopped the NLRB from enforcing this unnecessary and burdensome rule. This administration is making a habit of using regulatory policies to strengthen unions and harm the economy. In these difficult times, the last thing government should be doing is putting roadblocks in front of American businesses as they attempt to do their part to turn our economy around and to create jobs. In the 74 years of the NLRB's existence prior to 2009, the board had promulgated just one substantive rule. It is time that the NLRB return to its main function, which is to act as a quasi-judicial agency. These actions by the NLRB further push our government down a dangerous path, one in which decisions no longer lie in the hands of those elected by the people, but by unaccountable bureaucrats sitting in Washington, disconnected from people. For these reasons and many others, I'm supporting Senate Joint Resolution 36, and I want to encourage my colleagues on both sides of the aisle to stand with American employees and employers and to vote to stop the NLRB from moving forward with what is a misguided and deeply flawed ambush election rule. And I congratulate the senator from Wyoming for getting this on the floor and giving us an opportunity to debate it. Mr. President, this is yet another example of an administration that seems to be bent upon creating more excessive, overreaching regulations, making it more difficult and more expensive for American small businesses to create jobs and to get this economy growing again. Mr. President, I hope my colleagues will join me in voting to stop this from happening, and I yield the floor.
I just read it.
Jeff.
Make sure you charge it before we start.
President, I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Kaka.
Senators are debating a National Labor Relations Board rule that would speed up union elections. A vote is planned this afternoon on a motion to block the rule. Then the chamber is expected to hold a series of votes on changing the U.S. Postal Service. Nearly 40 amendments are standing by. Congressional Quarterly writes that contentious amendments to the post office bill generally fall into two categories. One batch would seek to impose more cuts on the Postal Service, and the other would seek to block or delay other changes proposed by the Postmaster General.
Ask that further procedure in the quorum call be dispensed with.
Without objection.
How much time is remaining, Mr. President?
I can do it for you. The Senator suspend.
And Brown is not coming.
Okay.
It's about
7 minutes for the remaining. No, 5 minutes for the majority. 5 minutes for the majority.
5 minutes for the majority.
3 minutes for the minority.
3 minutes for the minority.
All right. Mr. President, I'll obviously yield to my good friend Senator Enzi for his closing remarks. But I just again want to point out that this ruling by the NLRB is eminently reasonable. They went through rulemaking. As I've said before, one of the most transparent boards we've ever had in history. Rather than going through the adjudicated process, they went through rulemaking, comment period. People were allowed to come in, and they even had an oral hearing, which is not even required by the Administrative Procedures Act. Mr. Hayes was allowed due time for filing dissents. He chose not to do so for whatever reason. And so everything was complied with. In fact, they bent over backwards to even do more than what the Administrative Procedure Act requires under rulemaking. So that's number one. Number two, the essence of the rule is eminently fair. It applies both to certification and decertification. There is no 10-day, I keep hearing this 10-day thing broke out. Mr. Hayes put that in his dissent, but there's nothing in the rule that requires a 10-day election. Nothing, period. Lastly, again, what is this all about? I will say it one more time. This is what it's about. This is it. This is Mr. Martin J. Levitt, who wrote a book, Confessions of a Union Buster. He was a consultant to businesses who wanted to bust unions or didn't want to have unions formed, and here's what he said in his book. Here's the way that they should do things if they don't want to have a union. Challenge everything. Then take every challenge to a full hearing. Prolong each hearing. Appeal every unfavorable decision. If you make the union fight drag on long enough, workers lose faith, lose interest, lose hope. That's what it's about. It's about establishing a level playing field now so that workers do indeed have their full right, not a paper right, but a really full, viable right to form a union and to have an election within a reasonable period of time. With that, Mr. President, I yield the floor, and if my friend needs some more time, I'll yield him whatever time I've got remaining.
Mr. President,
The senator from Wyoming.
I want to thank the chairman for the gift of time. There's nothing that's a greater gift than that. Of course, I would like everyone to vote for my resolution of disapproval. This did not go through a process that was open and transparent. In fact, there was only one person that voted for this that was confirmed by the Senate. There were two people that voted for it. The other one lost in a bipartisan way the ability to be on that committee, so he was recess appointed. So one person confirmed by the Senate is making this rule. And there was also one person confirmed by the Senate that was against it. So it was a 1-to-1 tie. That would normally defeat anything. So, and the biggest thing that's being taken away in this, the biggest thing that collapses the time down to a potential 10 days, the biggest thing is eliminating the pre-election hearing. That's when the employees get their fairness of finding out exactly who's going to be represented, who's going to be part of their unit, and get any of their questions answered about this organization that's about to receive their dues. It seems like the employees, for fairness, ought to have that right. It also ought to be for the employers to have that right, especially small businessmen, to have the time to get it together so that they're not violating any of the National Labor Relations Board's rules that they can easily step into and be in big trouble during one of these elections. I urge all of my colleagues to support this resolution of disapproval and stop the National Labor Relations ambush election rule. This vote will send a message to the National Labor Relations Board that their job is not to stack the odds in favor of one party or another, under this administration or another, but to fairly resolve disputes and conduct secret ballot elections. We've heard from several speakers on the other side of the aisle that this debate and vote are a waste of time. Debating the merits of this regulation is not a waste of time for the millions of small business people and millions of employees that are going to be negatively impacted by it. In fact, once it goes into effect next week, I believe that all of us will be hearing from unhappy constituents and asked what we did to stop this legislation, and we will be asked. The contention that we should not be able to raise concerns about the National Labor Relations Board's ambush election regulation before it goes into effect sounds a lot like the National Labor Relations Board is what they're trying to do to small businesses and employees who have questions about a certification election. This regulation will take away the right to question whether the appropriate employees are in the bargaining unit, or whether it includes supervisors and managers that should not be in the union, or whether it leaves out a group of employees that should be in the union because they have similar jobs, and if they're excluded, they'll probably lose ground against the newly unionized employees. This regulation takes away the right to present evidence and testimony at a pre-election hearing and to file briefs supporting a position. Because of the Congressional Review Act, we senators have had the opportunity to present evidence and have debate. That's a privilege the NLRB is taking away from many small employers and employees, and that will lead to some suffering of the employees. So I urge my colleagues to vote for the motion to proceed to SJ Res 36. Again, it's a congressional privilege, and we should take advantage of it. It's a chance to send a message that we want all of our boards to be fair and equal. I thank the chair and yield the balance of the time.
Under the previous order, the Senate will resume consideration of the motion to proceed to S. 1925.
Mr. President, I'd yield back any remaining time.
Time was yielded back. The senator from Arizona.
Mr. President, I wanted to discuss one of the amendments that I believe we'll be voting on later on. And basically what it does, it establishes a BRAC-like process in order to consolidate redundant, underutilized, and costly post offices and mail process facilities. Now, Mr. President, we found over the years that Congress was politically unable to close a base or a facility that had to do with the military. And so we adopted a process where a commission was appointed. Those recommendations to consolidate excess and underutilized military bases was developed, and Congress was given an up or down vote. This is sort of based on that precedent. The bill before us clearly doesn't offer any solutions. According to the Washington Post editorial, quote, the 21st Century Postal Service Act of 2011, proposed by Senators Joseph Lieberman and Susan Collins and passed last week by the Senate Committee Homeland Security Government Affairs, quote, is not a bill to save the U.S. Postal Service. It is a bill to postpone saving the Postal Service. I agree with the Washington Post. I usually do. The service's announcement that it lost $5.1 billion in the most recent fiscal year was billed as good news. That's how dire the situation is. The fact that they only lost $5.1 billion. The Collins-Lieberman bill transfers $7 billion from the Federal Employee Retirement System to the USPS to be used for offering buyouts to its workers and paying down debts, can stave off collapse for a short time at best. Nor do the other measures in the bill offer much hope. The bill extends the payment schedule for the Postal Service to pre-fund its employee retirement benefits from 10 to 40 years. Yes, the funding requirement is onerous, but if the USPS cannot afford to pay for these benefits now, what makes it likely they will be able to pay later when mail volumes most likely have plummeted further? The bill also requires 2 more years of studies to determine whether a switch to 5-day delivery would be viable. These studies would be performed by a regulatory body that has already completed a laborious inquiry into the subject, a process that required almost a year. Washington Post goes on to say, this seems a pointless delay, especially given that a majority of Americans support the switch to 5-day bribery. And finally they go on to say there is an alternative, a bill proposed by Representative Darrell Issa that would create a supervisory body to oversee the Postal Service's finances and, if necessary, negotiate new labor contracts. The bill is not perfect but offers a serious solution that does not leave taxpayers on the hook. So we now have a legislation before us that makes it harder, if not impossible, for the Postal Service to close post offices and mail processing plants by placing new regulations and limitations on processes for closing or consolidating mail processing facilities, a move in the wrong direction. It puts in place significant and absolutely unprecedented new process steps and procedural hurdles designed to restrict USPS's ability to manage its mail processing network. Additionally, the requirement to redo completed but not implemented mail processing consolidation studies will ultimately prevent any consolidations from occurring this calendar year. Mr. President, what we have to realize in the context of this legislation is that we now have a dramatic shift, technologically speaking, as to how Americans communicate with each other. That's what this is all about. We now have the ability to communicate with each other without sitting down with pen and paper, just as we had the ability to transfer information and knowledge by means of the railroad rather than the Pony Express. So we now have facilities that are way, way oversized and unnecessary, and we are facing a fiscal crisis. According to the Postal Service, quote, "The current mail processing network has a capacity of over 250 billion pieces of mail per year, when mail volume is now 160 billion pieces of mail." So we now have the overcapacity of nearly double what is actually going to be the work that the Postal Service does. And all trends indicate down. More and more Americans now acquire the ability to communicate by text messaging, Twitter, or many other means of communications. So to somehow get mired into, well, we can't close this post office, we have to keep this one up, we have to do this, we have to realize it in the context that the U.S. Postal Service is now a large portion of their business is conducted by sending what we call, quote, junk mail, rather than the vital ways of communicating that it was able to carry out for so many years. The Postal Service has a massive retail network of more than 32,000 post offices, branches, and stations that has remained largely unchanged despite declining mail volume and population shifts. The Postal Service has more full-time retail facilities in the United States of America than Starbucks, McDonald's, UPS, and FedEx combined, and according to the Government Accountability Office, approximately 80% of these retail facilities do not generate sufficient revenue to cover their costs. That's what this debate is all about. And I hope that my colleagues understand. We are looking at basically a dying part of America's economy because of technological advances, and we basically in this legislation are not recognizing that problem. When 80% of their facilities don't generate sufficient revenue to cover their costs, then any business in the world, in the United States of America, would right-size that business to accommodate for changed positions. This bill does not do that. It continues to put up political roadblocks that prevent tough but essential closings and consolidations. I agree for the individuals who took care of the horses when the Pony Express went out of business. I agree for the bridle and saddle and buggy makers when the automobile came in. But this is a technological change which is good for America in the long run because we can communicate with each other instantaneously. So we have a Postal Service that, thank God for all they did all those years, in fact, to the point where they were even mentioned in our Constitution. But it is now time to accommodate to the realities of the 21st century. And the taxpayers cannot continue to pick up the tab of billions and billions of dollars. Again, last year it lost only $5.1 billion, which they suggested was good news. So all it does, this bill, it placed significant and absolutely unprecedented new process steps and procedural hurdles designed to restrict USPS's ability to manage its mail processing network. Additionally, the requirement to redo completed but not implemented mail processing consolidation studies will ultimately prevent any consolidations from occurring this year. So what do we need to do? We obviously need a BRAC. We need a group to come together to look at this whole situation, find out where efficiencies need to be made, as any business in America does, and come up with proposals, because Congress does have a special obligation, and have the Congress vote up or down. This bill will continue the failing business model of the Postal Service by locking in mail service standards for 3 years, which are nearly identical to those that have been in place for a number of years. The clear intent of this provision is to prevent many of the mail processing plant closures that the Postal Service itself has proposed as part of its restructuring plan. It It also prohibits the Postal Service from moving to 5-day mail delivery for at least 2 years with significant hurdles that must be cleared before approval, even though the Postmaster General has been coming to Congress since 2009 and asking for this flexibility. One of the largest single steps available to restore USPS's financial solvency would save the Postal Service at least $2 billion annually. Now, how many Americans, if you told them that we would save them, the taxpayers' dollars, because they're on the hook, $2 billion a year if you went from 6-day to 5-day mail delivery? I guarantee you that the overwhelming majority of Americans do support a 5-day delivery schedule rather than 6. This, of course, being kicks the can down the road. The bill also has at least 5 budget points of order against it, about which the ranking member of the Budget Committee came to the floor yesterday and spoke about. So, the BRAC-like amendment is essential, in my view, to moving this process forward. I don't know how many more billions of dollars of taxpayers' money is going to have to be spent to adjust to the 21st century. And there is no business, there is no company, there is no private business in America that, when faced with these kinds of losses, wouldn't restructure. And they would restructure quickly because they would have an obligation to the owners and the stockholders. We are the stockholders. We are the ones who should be acting as quickly as possible to bring this fiscal calamity under control. The GAO, the Government Accountability Office, states the proposed Commission on Postal Reorganization could broaden the current focus on individual facility closures, which are often contentious, time-consuming, and inefficient, to a broader network-wide restructuring similar to the BRAC approach. In other restructuring efforts where this approach has been used, expert panels have successfully informed and permitted difficult restructuring decisions, helping to provide consensus on intractable decisions. As previously noted, the 2003 report of the President's Commission on the USPS also recommended such an approach relating to the consolidation and rationalization of USPS's mail processing and distribution infrastructure. You know, we pay a lot of attention to the Government Accountability Office around here, and this is also something that the Government Accountability Office recommends as well. In addition, GAO reviewed numerous comments from members of Congress, affected communities, and employee organizations that have expressed opposition to closing facilities. Such concerns are particularly heightened for postal facilities identified for closure that may consolidate functions to another state, causing political leaders to oppose and potentially prevent such consolidations. We should listen to the Government Accountability Office, take politics out of this delicate process, and move forward with their recommendation. Our proposal would be composed of 5 members appointed by the President with input from the House and Senate and the Comptroller General, with no more than 3 members being of the same political party. The Postal Service, in consultation with the Postal Regulatory Commission, will be required to submit a plan to the BRAC-like Commission on Closures and Consolidations, which will include a list of closures and consolidations, a proposed schedule, estimated annual cost savings criteria, and process used to develop the plan, methodology, and assumptions used to derive the estimates, and any changes to processing, transportation, delivery, or other postal operations anticipated as a result of the proposed closures and consolidation. The Commission will be required to publish in the Federal Register the definition of, quote, excess mail processing capacity with a period of public comment. After receiving the plans, the BRAC-like Commission will be required to hold at least 5 public hearings. Finally, the Commission will be required to vote on the recommendations with a concurrence of at least 4 of the members and submit the recommendations to Congress, and any recommendation would be a subject of a congressional vote of approval or disapproval. The amendment recognizes the fact that the current business model for the Postal Service is no longer viable. If we continue to act in an irresponsible way by putting up political roadblocks, the American taxpayer will be the one that ultimately suffers in the form of higher postage prices and bailouts. We should make hard choices now so that future generations of Americans will have a viable postal service. Mr. President, I ask unanimous consent. The Washington Post editorial, "A failure to deliver solutions to Postal Service's problems," be included as part of the record. So, Mr. President, I don't know what the ultimate result of the votes here in the Senate will be. I do know that if it passes, it will be strongly opposed in the other body in the House of Representatives. If it is passed and signed into law, we will be back on the floor within 2 years addressing this issue again, because this is not a solution. This isn't even a Band-Aid. It is a proposal that will do business as usual and an abject failure to recognize that there's technological changes that make certain practices obsolete. And that's what this is all about. And it's painful, yes. Is it difficult? Yes. But the overall taxpayer, obviously, I think, wants us to act in a fiscally responsible manner. Mr. President, I yield the floor.
Senator from Connecticut.
President, knowing that we're scheduled to go out at 12:50, I want to ask unanimous consent that we stay in session for no longer than 10 minutes more, so we'll break at 1 p.m. for Senator Collins and I to respond to Senator McCain, hopefully sooner than that.
Without objection.
I thank the chair particularly, since the chair will be occupied by the distinguished senator from Montana between now and then. Mr. President, I want to respond to the statement my friend from Arizona made very briefly with a couple of big points. The first is that Senator McCain, I think, has declared the Postal Service of the United States dead much too prematurely. He compares it to the Pony Express. Of course, electronic mail and other changes have occurred, but today, every day, the Postal Service delivers 563 million pieces of mail every day. There are businesses and individuals all over our country that depend on the mail. The estimate is that there are approximately 8 million jobs in our country, most of them, of course, almost all of them, in the private sector, that depend in one way or another on the functioning of the U.S. Postal Service. So it's not fair, it's not realistic to speak as if the Postal Service is dead and gone and to come to essentially bury it with the McCain substitute. I cannot resist saying that Senator Collins and I come not to bury the U.S. Postal Service, but to change it, but to keep it alive and well forever, really, because it's that important to our country. Secondly, Senator McCain speaks as if the substitute legislation 1789 that we're proposing, bipartisan legislation, does nothing, that it's a status quo piece of legislation. It's not even a Band-Aid on the problem. Well, we all know, we've talked about it incessantly since we went on this bill, that the Postal Service is in financial difficulty. Incidentally, I want to say there's not a dime of taxpayer money in the Postal Service. Ever since the Postal Service reforms occurred, it's totally supported by ratepayers, basically by people who buy the services of the Postal Service, with two small exceptions, which really are small. One, to pay for overseas ballots for members of the military so they can vote, and another, it's a special program to facilitate the use of the mail by blind Americans. So, but it's got a problem, $13 billion lost over the last 2 years. This proposal of ours, Senator Collins and I, Senator Carper and Senator Scott Brown, it's not a status quo proposal. It makes significant changes. There are going to be about 100,000 fewer people working for the Postal Service as a result of this bill being passed. There will be mail processing facilities that close. There will be post offices that will be closed and or consolidated. there'll be new sources of revenue for the Postal Service. Bottom line, the U.S. Postal Service itself estimates that our legislation, if enacted as it is now, will, as it's phased in over the next 3 to 4 years, by 2016 will save the Postal Service $19 billion a year. This isn't a Band-Aid. This is a real reform, a real transformation of the Postal Service to keep it alive. $19 billion. And let me put it another way. This is a bipartisan proposal. We've worked on it very hard to keep it bipartisan. We think it can pass the Senate and it can ultimately be enacted. If Senator McCain's substitute were to pass, nobody thinks it's going to get enacted into law. It won't. Certainly the President of the United States won't sign it, and that'll mean nothing will be done. And what will be the effect of that? That the Post Office will go further and further into debt and deficit, and the Postmaster will be faced with a choice of either those enormous debts and deficits or taking steps that will make the situation worse, that our bill, through a reasonable process, is trying to avoid, which is a kind of shock therapy whose effect will be, as the McCain substitute would be, to actually drop the revenues of the Post Office and accelerate its downward spiral. And I think the two numbers to think about, the ones come from the Post Office itself, from the Postal Service. By 2016, if we do nothing, the Postal Service will run a somewhere between $20 and $21 billion deficit, annual deficit. If we pass this bill and it's enacted into law, that deficit will be down to around $1 billion, a little more, and heading toward balance in the years that follow. So I urge my colleagues to vote against the McCain substitute and the Brack Amendment, which I think is not necessary. It's not necessary for us in Congress to give up and give in. We've got a good resolution to the problem here. And incidentally, if we get this enacted, I think we're going to send a message to the American people that we can face a tough problem in a public service, deal with it in a reasonable way, ask people to sacrifice, but keep a venerable and critically important American institution alive and well. I thank the Chair, and I yield the floor to my distinguished ranking member.
Mr. President.
The senator from Maine.
Thank you, Mr. President. Mr. President, I'm only going to speak very, very briefly. I want to shine a spotlight on a provision of Senator McCain's substitute that has not yet been discussed that actually raises constitutional issues. Now, all of us believe that the labor force of the Postal Service is too large and unfortunately will have to be reduced. And we do that through a system of buyouts and retirement incentives, through a compassionate means very similar to the way that a large corporation would handle the downsizing of its employees. But Senator McCain's alternative takes a very different approach. It would have this new control board that would be created to impose on the Postal Service an obligation to renegotiate existing contracts to get rid of the no layoff provision. Now, Mr. President, I will say that I was very surprised when the Postmaster General signed the kinds of contracts that he did this spring. But the fact is that Senator McCain's amendment, Section 304, which amends Section 1206 of existing law, requires existing contracts to be renegotiated. That creates constitutional questions. The potential constitutional issue derives from the contracts clause of Article 1, which prohibits states from passing laws impairing the obligation of contracts. While, of course, this provision does not apply to the federal government, the Congressional Research Service has explained in a memorandum to me on this topic in July of 2011 that the Due Process Clause of the Fifth Amendment has been held to provide some measure of protection against the federal government impairing its own contracts. And I would ask unanimous consent that the CRS memorandum that I just referred to be entered into the record.
Without objection.
There's also a Supreme Court case, Lynch versus the United States, that makes clear that the Due Process Clause prohibits the federal government from annulling its contracts, and the United States is as much bound by its contracts as are